Hello, my name is Austin, and today I want to talk a little bit about the accessibility laws and why it's very complicated when it comes to website accessibility. One of the big issues that's been occurring in the space is that the ADA, which is the Americans with Disability Act, was founded in the 1990s, which is really before the rise of the internet and websites and mobile applications that we all use today. So the question from the court standpoint is, without an update to the ADA, it's not clear whether this new technology, these websites and things, are part of the public accommodation. Obviously, I feel that they are, and I think most people would agree that, you may go to a mall or a restaurant and now people, are using, Uber Eats or DoorDash, or shopping online with Amazon. So it's the same type of space. It's just it's just digital now. And the same service activity is occurring. And we've seen that with some of the rulings. So I'll bring up, for example, Domino's Pizza. Domino's Pizza got sued because their mobile app was inaccessible, and people would who use screen reading software and have generally some kind of vision loss or are blind, were not able to access the app with the screen reader. So Domino's was sued, and successfully they lost the case. Court stressed in the Domino's lawsuit that the ADA applies to services of public accommodation, not just on public accommodation. In addition, though, what I want to kind of mention here is that each court has their own interpretation. So some courts really rely on there being a nexus, or the digital service being tied to some physical space. For example, let's say you use an app to order a prescription for CVS. The app that you're using is tied directly to the physical space of where you're going to get the prescription. So therefore there is a nexus or connection between the physical and the digital. You could see that as well when it comes to coupons or something like that. If you're shopping, let's say for Target on coupons, the coupons that you're shopping for are tied to the physical space of the Target store. So therefore there is a connection. So it needs to be it's included as a public accommodation. Now, other courts say you don't need that nexus, and it can still be viewed as public accommodation because websites and the online space is part of is a public accommodation. So you kind of have different viewpoints there, and other courts obviously are starting to say that you don't need, that. Recently, a Winn-Dixie lawsuit regarding their app being inaccessible for ordering prescriptions for people who use screen reading software was overturned in favor of Winn-Dixie. And the court was saying you don't need to make that app accessible for people with disabilities, that the person with a disability could still go to the store and order the prescription. They may have to wait in line, but they could still do it, and therefore the app really isn't necessary because there's an alternative way of doing it, or they could call or whatever. But the idea, and generally other courts have kind of said that calling or being able to go there physically, if it's not as convenient, doesn't really mean that that channel of, let's say, calling or going there physically can replace the need for an accessible website or accessible mobile application. So I feel like that kind of just gives you an idea a little bit about the space, and I'll include some articles to check out. But basically, the big issue here is that A, the ADA has not been updated, and B, the Supreme Court has really not taken on any case relating to web accessibility. Because the ADA has not been updated to include web accessibility guidance, and the Supreme Court has not taken on any web accessibility lawsuit, there right now is a lack of guidance about how the ruling should be, so it's left up to individual state districts, and some districts are more in favor of people with disabilities and accessibility than others. And that's kind of the space how it is right now. And hopefully in the future we will get some further guidance. I would like to see the web accessibility, web content accessibility guidelines, the WCAG standards, which are really guidelines to make websites and mobile applications accessible. become adapted and be part of the ADA in some way, of saying, maybe the level 2 standard, AA standard is what's necessary on there to have your website or mobile application deemed accessible. And that would require, let's say major corporations, not everybody, but major companies, I think, should be required to meet those standards. And I think, individuals and smaller companies should be, encouraged and told to try and meet those as well. But in any case, I think that's kind of the space right now. It's really a developing space, and there has been a lot of activity and updates there. So definitely check it out. And thank you so much for watching.